Hello, welcome back. Today is Wednesday, August 6th, and we're covering three more federal cases involving First Amendment challenges and also 14th Amendment challenges. And today we're going to be talking about student rights and teacher rights. The first case we'll be talking about is Lipp versus Morris. It was decided in 1978. And Mary Lipp, a student, high school student, challenged a New Jersey state statute requiring students to stand at attention during saluting the flag each day. And the question before the court was, is it a violation of the First and 14th Amendment? And in this case particularly, Mary refused to stand and said that the words of the Pledge of Allegiance were not true, and she stood only because she had been threatened if she did not do so. So I want you to read the case carefully and notice that this is an appeals court decision. It is not a decision rendered by the United States Supreme Court, and that's significant. And as you know, an appeals court looks carefully at a lower court and then makes its decision. So it'd be beneficial, I think, if you read both the district court's decision and the appeals court decision to try and understand why this decision was brought forth, and look closely at the language. What did the appeals court confirm? I want you to look at the legal terms. There are many legal terms that we have not seen before in this case, and we're going to get into more legality in the language as we go on. So the appeals court pretty much said that you don't have to stand. Students, remember in Tinker we said that students do not lose their constitutional rights when they enter the schoolhouse door, and that seems to be affirmed here, in that students in protecting their First Amendment freedom of speech exercise do not necessarily have to stand when the requirement is made by a state law or a local requirement to stand during the Pledge of Allegiance or the flag salute, whichever you choose to call it. So an interesting case, but also the question that you need to think about here, where does the appeal court decision have authority? Is it across the country simply because it is a federal court, or is it specifically within the appeals court district? Take a look at that. So the second case we'll be talking about is Palmer versus Board of Education. This is a teacher this time, not a student. And in this case, it was a U.S. District Court decision in 1979. And Palmer was a teacher. And Palmer is asking for injunctive relief. So again, it's interesting. Take a look at this term, injunctive relief. What does it mean to you? And the plaintiff was fired for her refusal to teach the Pledge of Allegiance. The plaintiff was a kindergarten teacher, and the teacher, on religious grounds, she was a Jehovah's Witness, refused to teach the Pledge of Allegiance. She refused to teach patriotic songs. She refused to teach anything about national holidays or anything patriotic, and she used her religious belief as a basis for that. Well, she was subsequently fired, even though the school took a lot of attempts to ameliorate her request, but it got to the point where parents and teachers just notified things that were happening in the classroom that did not support good instruction, and she was fired. So take a look and see whether or not this particular case was how it turned out, and again, there's another term called compelling state interest and curricular nonconformity. The case is rather lengthy, but I'd like for you to once again look at those legal terms to see what what they meant. It's interesting to me in this case that it didn't go very far. The court quickly said, the district court decided in summary judgment for the defendant. So what does summary judgment mean? It's interesting also that protected activity versus non-protected activity was determined in this case. So there are many things going on here besides just a First Amendment issue which the plaintiff alleged. So it's an important case as well. So the final case that we'll be discussing this week is Russo versus the Central School District. It was decided also in federal district court in 1972, in federal appellate court in 1972, where we also have a probationary teacher who refused to participate in flag ceremonies, although the teacher did stand during the flag salute. She simply did not pledge allegiance and recite the pledge. She simply stood with her hands at her side, was respectful, but was subsequently fired by the school board at the end of the year. And this case, again, is very interesting, and you need to read the entire thing to get the gist of what happened. But basically, the court affirmed that teachers do not necessarily have to pledge or recite the Pledge of Allegiance in this particular case. But the case lends itself to a lot of employment issues that we'll be talking about later on in other cases as we go through the course. So once again, three good cases that we'll talk about, hopefully in great detail as you respond to the questions this week. And if you'll look at the forum question, how do you, as a teacher or a school administrator, teach patriotism in your school? I know as a middle school principal, I expected my students to stand respectfully during the flag salute each day. I didn't really worry whether or not that it was legal or not. It was my expectation. In my career, I worked mainly in small conservative communities, and that was an expectation of the community, and it was also an expectation of mine. How do you feel about it? What is your district's requirement? What does your school board attorney think about that? Will be interested in hearing your responses to those questions. So have a good week. Thanks.